Yes.
Yes, my lady and my lords. So just where we left off before the break, I had just finished going through the pleadings in the commercial court to demonstrate where we say the term which Global proposed should be implied into the MOMA had been expanded. And I'm now going to get into the 4 reasons why we say that term should not be implied into the MOMA. The first reason is the fact that the authorities have held that the question of implication arises when an instrument doesn't expressly provide for a particular event. In the case of Marks and Spencer, and I don't need to take my lords and my lady to that particular authority because I'm sure it is well known, but nonetheless at paragraph 28 of that decision, Lord Neuberger advances a sequential approach in terms of the implication of terms. To construe the contract first, to see what was expressly there, and then decide if the interpolation of any words become necessary. Now, in this particular case, what Global would be seeking to allege in reference to what we say is the wider formulation of the term is that no plant had been provided. Certainly, that is the term that the Court of Appeal advances, and I will demonstrate later on that Global essentially flip-flops, so to speak, in this regard. But certainly in respect of the alleged breach in these particular circumstances, we say that clause 8.1 of the MOMA, and that is at MS page 531, would have been able to cater for the alleged breach in these particular circumstances. Now, clause 8.1 concerns the government representing that it is the owner of the treatment plant under the MOMA and providing access and egress from the plant, as well as the right to use, occupy, and have access to the plant, granting the company, the right to use, occupy, and have access to the treatment plant. So our position is based on the allegation of the proposed wider formulation of the term, insofar as it relates to the provision of a treatment plant under the MOMA, that an allegation that clause 8.1 had been breached would have sufficed. And in those circumstances, there would be no need to imply any term to cater for the breach that occurred in this particular scenario. Now, it may have been that the need to imply the term not prevent the commencement date of the MOMA or not prevent the commencement or the performance of the MOMA is a term that needed to be implied in other circumstances. So, for instance, the treatment process that the plant envisages and my lords, I don't purport to be an expert in this respect at all, but certainly insofar as the plant, for instance, depending on disinfectant being used to treat the wastewater, if, for instance, government, because there is no direct or express obligation on government no direct or express obligation on government concerning anything concerning the disinfectant to be used in the plant. So if government, for instance, passed legislation or somehow did something to prevent the relevant disinfectant from being accessible to Global to process the wastewater, there may have been a need to imply a term to not prevent the commencement or the performance or the operation of the MOME, and that obligation would have been breached by us doing whatever we did in relation to the disinfectant.
But is there a general principle of contract law that you can't rely on your own breaches to say there's no liability? Because that would have been a breach, would it, of the DBA as well?
In terms of the...
Not allowing access to the excess water or passing legislation to prevent it altogether.
Yes, please, my lady. But what I'm saying is that if that had been the action on the part of government, preventing access to the disinfectant, if that was the action being complained of, there's no express obligation to provide you with the disinfectant, let's say. So the implication of a term to not prevent the commencement or the operation of the MOME by reference to the disinfectant would have been necessary because there is no express term that governs that situation in the MOME. But the action that is being complained about in these circumstances is not having access to a treatment plant that you can manage. And in that respect, we say that ground is completely covered by Clause 8.1. And insofar as it is covered by Clause 8.1, there's no need to go to an implied term.
Thank you. Thank you.
When would the 8.1 obligation come into effect?
Well, my lord, we would say from the time that contract was executed.
Well, at the time the contract was executed, there was no treatment plant, and there was no plant to give occupation or access to.
Well, my lord, at the time 8.1 was executed, there was no DBA treatment plant or no treatment plant.
At all?
Well, no treatment plant built pursuant to the DBA, certainly, my lord.
But your point may be a good one if 8.1 could stand as an obligation prior to a commencement date, but it can't, can it?
Well, my lord, and again, the commencement date is referable to the commencement date of the MOME. And my lord, I will come to demonstrate in due course why we say that the contracts are not inextricably linked, at all.
My point is that the obligations in clause 3.1 are for a period of 12 years effective from the commencement date. So 8.1 only binds the government after the commencement date.
Yes, please, my lord, indeed. But, my lord, the point I'm trying to make is the fact that the DBA plant did not come to fruition did not mean that there was no treatment plant for the purposes of 8.1, because certainly it is our position that those would be two completely different questions or considerations.
Okay.
Because it is our position that the MOME was a freestanding contract.
Yes.
Yes, please, my lord.
Thank you.
So, my lord, that would be the first reason why we say the wider formulation of the term ought not to be implied. Now, the second reason, and before I get into the other three reasons, as a matter of fact, because the other three reasons are procedural in our view, and they stem from Global's ability to make one of two arguments. First, either that this wider formulation of the term was advanced before the arbitration, but was not considered, or that it was not advanced before the arbitrators, but ought to have been considered. So, in respect of the first, that is to say, an argument that the wider formulation was advanced, but was not considered, we say that the challenge in that respect must fail because the alleged failure to consider the wider formulation is not patent on the face of the award. And the award, of course, starts at page 1 of the bundle.
I'm not sure if that proposition would be contested, that it's not patent on the face of the award. I'm not sure.
Well, Well, Lord, certainly.
The award
Didn't Mr. Strong say it would be misconduct?
Well, Lord Sale said that, please, my Lord. I'm not sure that Mr. Strong directly agreed that it would not be an error on the face of the award at all.
Well, paragraph 15 says that Global's entire case is X.
Yes, please, my
and
Lord.
that there's nothing else in the award to say that it was non-X or it was wider than X.
Yes, please, my Lord. Well, if that is a point that is accepted, well, certainly.
I don't know if it's accepted, Mr. Strong, but I mean, I'm just putting to you, is that the point you're making?
Yes, please, my Lord. And in addition to paragraphs 15, paragraph 3 on page 4, paragraph 19, and paragraph 21 of the award also make the same point. At every point where the arbitrators referred to the term to be proposed, it was always what we refer to as the narrow formulation of the term, the provision of a prepared site, not the provision of a plant.
So sorry, can you give me those paragraphs?
Certainly, please, my Lord. Paragraph 3, but it's the portion of paragraph 3 of the reasons, which is on page 4 of the record. Paragraph 15.
Yes.
Paragraph 19.
Yes.
And paragraph 21.
Thank you very much.
Thank you.
Yes, please, my Lord. So, my Lord, as I said, this particular submission is that the error would not have been patent. The error, if the error is that it was in fact argued, but not considered by the arbitrators. And we do agree that it may have amounted to misconduct, but certainly not an error of law on the face of the award.
Yes, I think the point that I was putting to Mr. Strong was that in that situation, the right course for his clients, if they wanted to raise it, was to bring a claim of misconduct and
on
say
that
the
basis.
point
Indeed,
had not
please.
been raised.
Indeed, please.
It wouldn't be a case that it amounted to an error of law on the face of the record.
Indeed, please, my Lord. And if an authority is required for the proposition, we rely on that of the National Housing Trust. It's a 2015. So it's National Housing Trust and YP Seaton and Associates Company Limited, and it's at tab 22 of the bundle. And my lords, I wouldn't necessarily belabor the point, but I would direct the court's attention to the discussion of jurisdiction. And that starts at paragraph 36 of the decision.
Sorry, paragraph
36.
Thank you.
So it's MS 1262. And around the middle of paragraph 36, the Privy Council held that the question of jurisdiction arises in a more fundamental way. And just by way of background, in this particular decision, it was challenging an award of compound interest in this particular matter. Yes, please, Lord.
Yes, I vaguely recall it.
And just contrasting the approach of the court at paragraph 36, where the question of jurisdiction entitles the court to look at all the relevant documents, versus paragraphs 61 to 64, where if the complaint is an error on the face of the award, you have to construe those documents that constitute the award and see if on those documents the error being complained of is manifest.
Yes, this is the tripartite or three-stage process that you mentioned before.
Yes, please, my lord, indeed. and my lady. Moving on to the position where if Global's complaint is that the breach or the alleged breach, the failure to provide a plant, is one that should have been arrived at, although it was not referred, there are two arguments we make in respect of that. The first contention is that to invalidate an award, the point in question must have been specifically raised, so that it is actually fatal to not raise the particular contention before the arbitrators and then challenge the award on the basis that the arbitrators failed to consider the particular matter. Now, in support of this contention, we rely on the Russell on arbitration. It is at tab 3 of the authorities bundle. But more importantly, I would wish to take the court to the case of the National Housing Trust. And again, this is the decision of the board previously referred to, but in particular paragraph 52, which is on MS 1267, makes the point pellucid.
Paragraph
52, please, my lord.
MS number?
1267.
1267. Sorry, I was just looking at Russell to see what it was you were referring to there. 1267, thank you.
But my lord, I can certainly take the board to Russell because it's a very short, it is a very short passage, so it is on page 929, MS 929.
Is it the passage at the bottom of the page?
Yes, please, my lord.
Matters not brought to arbitrator's notice.
Yes, please, my lord.
Thank you very much. I saw that. Thank you.
So at paragraph 52 of National Housing Trust, the second sentence, deciding a case on a basis not covered by submissions or evidence in the board's view clearly constitutes misconduct justifying setting aside under section 12.2 of the Arbitration Act. And this is 12.2 of the Arbitration Act of Jamaica, which is in paramateria with section 24 of the BVI Arbitration Act. So the Privy Council actually states the position in the positive, but it's the same concept as in the Russell on arbitration, that the decision of the arbitrators, the award, must be premised on evidence and submissions advanced during the arbitration.
Sorry, you said it's the same as...
Section 12.2, it's the same as section 24, please.
Is it not section
Sorry,
25?
25, yes, you're,
Right, sorry,
you're quite correct, because it's the power to set aside. Yes, please, my lord. Section 25.
Yes, thank you.
Yes, so it says that it clearly constitutes misconduct justifying setting aside under 12.2, but independently of whether it constitutes technical misconduct, it also constitutes a cause for remission under 11.1.
I think it would be section 24.
Yes, please, my lord, you are indeed correct. So, my lord, we say that it would have been fatal to not submit this matter to arbitration and then attempt to challenge the arbitrator's failure to consider the matter that was not referred in these proceedings. Now, in determining whether or not the matter was, in fact, part of the arbitration proceedings, that is a question of jurisdiction. And although my learned friend made the distinction between jurisdiction as opposed to the pleading point, we rely on the National Housing Trust, the very same authority, to say that there is no such distinction to be made. In considering whether the arbitrators had jurisdiction to consider the matters that they did and arrive at the decision that they did, the court is entitled to look at everything, including the pleadings advanced before the arbitrators. And that becomes very clear when we look at paragraphs 36 and 37 of the National Housing Trust case, and that is MS 1262. And just right before I move on, my lords and my lady, I don't need to take the board to it, but just to indicate that the case of Zamalt, this was the very first case I referred to that sets the tone and in terms of the court giving deference to arbitrations, that case, in that case, the award was set aside on this very same basis. The fact that the award seemed to have been premised on matters that were not raised during the arbitration. In that case, it was a rent review, and there were certain conclusions that the arbitrator came to that the court held had not been ventilated during the proceedings, and that was the basis on which that particular award was set aside. So just to make that point. But returning to paragraphs 36 and 37, I've read from around the middle of paragraph 36 where it says the question of jurisdiction then arises in a more fundamental way, and it requires examination of all relevant material, whether or not recited or referred to in the award. It involves in the first instance the interpretation of the scope of the reference to the arbitration, and then the court goes on to refer to the other things that reference to arbitration allowed it to look at. The provisional agreement, the compromise agreement, which were both expressly referred to in the reference, and further admissible background to all these documents is the loan agreement itself. Insofar as the Court of Appeal accepted as correct.
But sorry, just on that, I mean, what's being looked to as extraneous materials all predates the reference to arbitration and are being referred to as aids to interpretation of that reference. So the board seems to be focusing on the reference to arbitration so far as jurisdiction is concerned. I think that what Mr. Strong says in this case is if one looks at the reference to the arbitrators, that's put in very broad terms. And he says that does confer jurisdiction.
Well, and my lord, I will deal with that as well, because it is our position that the reference to arbitration was not in broad terms, and it did in fact refer to the DBA obligations. But I will take the board to those particular references. Yes, please, my lord. So, my lord, I just wanted to take the board to paragraph 37. Insofar as the Court of Appeal accepted as correct a submission by Dr. Barnett that any question of jurisdiction could only arise if the want of jurisdiction or some erroneous legal proposition was apparent on the face of the award, that submission and the Court of Appeal's acceptance of it were incorrect. They were both contrary to the well-established principle that an arbitration tribunal cannot give itself jurisdiction which it does not have. Aside from the very rare case into which nothing brings the present, where a tribunal is expressly given power to determine its jurisdiction finally for itself, it is for the courts to decide what jurisdiction has been conferred on an arbitrator. And, my lords, just to go back and to answer your question a little more fulsomely, my lord, although in this particular case, what the court referred to was the reference to arbitration and those documents, it is clear that the dicta says it could examine all relevant material. And certainly in this particular matter, we're saying that the pleadings are relevant as well, because it is in the pleadings that Global would have framed its case before the arbitrator. It's the pleadings that would have put the government on notice as to the claim that it was called upon to meet during the arbitration. And certainly that would have informed the pleadings on both sides, the evidence that was led, the cross-examination, the submissions, everything would flow from those pleadings, my lord.
I follow that point entirely, but in terms of jurisdiction, if the arbitrators didn't have jurisdiction to consider some particular aspect of the case, that would mean that they couldn't allow an amendment to the pleadings, let's say in the course of the arbitration, because it would simply be a matter outside the scope of the reference to arbitration. But I wonder if that is the position here. I follow what you're saying,
yes, please, my lord.
That the pleadings proceeded in a particular way, but just suppose that there had been an application by Global to amend its pleadings in the course of the arbitration. I do wonder whether, in fact, the arbitrators would have had jurisdiction to consider the claim as so reformulated.
My position would be yes, please, my lord. Certainly if they had amended and the claim before the arbitrators had now been changed or refined or well, you know, it was amended.
But if it were amended, if it were competent, or if it were within jurisdiction for the arbitrators to allow the amendment, how does this question of pleading become relevant to the question of jurisdiction?
Because the pleading is relevant now, because we have to look back to the arbitration to see the case that was before the arbitrators. If they had allowed the amendment at that time, the case before them itself would have been an amended case.
Yes.
So even if, so I don't see it as being possible that a party could seek to have that case amended after the fact, after the arbitral hearing has been conducted. Certain during the course of the arbitration, and it's no different from court proceedings, there's a stage at which you're allowed to amend your pleadings. But once pleadings are closed, once evidence has been led, that ability to amend your pleadings is no longer there. And at that stage, once you are locked into those pleadings, the idea that you can then shift the goalpost as you so please must be one that we implore the court to find unacceptable. So the idea, for instance, that all Global said in its pleadings was that they ought to have been implied term and disallowed the implication of any term, well then where would we be? Because it's no different using the analogy of a negligence claim. You would plead negligence, but then you are required to particularize it and say on what basis negligence has been made out in your case, so that the respondent would know, okay, if it was a running down action, for instance, fail to heed the traffic light, fail to heed traffic signals, hand signals, and not that you're saying that I suddenly stopped my vehicle, because 1 and 2 may not be the same case at all. And similarly, it cannot be that your pleading is at large and it's just the implication of any term conceivable, because I wouldn't know where to start to take instructions on a case that was pleaded as widely and vaguely as that.
Yes, I mean, quite apart from the question of whether there's jurisdiction, there is a pleading point that is being made. And you can say, well, the arbitrators were never asked to find that there was an implied term in the form that the Court of Appeal found.
Indeed, please, my lord.
Yes, and if that is the case, is that not a legitimate pleading point for you to take?
Well, my lord, insofar, because in National Housing Trust, what the jurisdiction issue that arose was whether or not the arbitrator had jurisdiction based on the general law or the contract or the claim that was lodged before it to award that compound interest. It was premised on the claim that was submitted to the arbitration. And what the court said in respect of the claim submitted, this is where the idea of jurisdiction came to be discussed in National Housing Trust. It was a question of whether, despite the fact that the common law didn't allow it, whether or not that was in fact the party's claim that allowed the arbitrator to deal with it. And then insofar as the contract didn't allow it, that is where they had their discussion on error of law and whether that error was something that was patent on the award. But that was separate and apart from its discussion in relation to jurisdiction or in relation to misconduct, although the jurisdiction and misconduct were inextricably bound. But that idea of whether the arbitrators had jurisdiction arose in the first place in that case because the court was exploring whether or not he would have been entitled to arrive at that determination and award compound interest based on the claim that the parties had submitted to arbitration in the first place.
Can we just get clear, Mrs. Jackman-Lumi, what the condition was that the Court of Appeal considered should be implied? If we've got paragraph 78 of their judgment, on page 83, we are looking at the Court of Appeal here, we are.
We are.
Fifth line down, the agreement was subject to the condition precedent that a plant of the requisite capacity was brought into being and provided to be managed. It was therefore implicit the government would do all that was necessary to achieve that milestone. In other words, bringing a plant of the requisite capacity into being.
Yes, please, Madam.
So perhaps I got muddled. I thought that was the narrow condition.
Oh, no, please, my lord. That's actually the wider condition. The narrow condition, as we see it, is the provision of a prepared site.
Which comes
in accordance with the DBA.
In accordance with the DBA, yes, please,
Yes.
my lord.
Yes,
Okay.
and that was the condition which the arbitrators said couldn't be read.
Indeed, please, my lord. And that's the condition that we say that Global had always agitated before the arbitrator should be implied.
Yes.
Thank you.
And just to track it through, you say, as I understand it, that's the case that was presented to the arbitrators, and then there is a significant shift as soon as you get the notice of appeal to the High Court,
yes, please,
where
my Lord.
the term is broadened.
Yes, please, my Lord, because in the commercial court, we now see an implied term to not prevent the commencement date, including by not providing the prepared site. So it left it open for other things to be ventilated, and certainly it is those other things, being the provision of a treatment plant, that Justice Leon actually found was or ought to have been implied.
Yes, so as I understand it, you say at the point of the appeal to the High Court, there wasn't a focused attack on the implied term that had been considered by the arbitrators. It was sought to raise a new implied term.
Indeed, please, my Lord, that's exactly the complaint. And insofar as that was the position, and insofar as the authorities all make it clear that you're unable to do that, it's fatal to your challenge to the award to take that approach. That's the third reason that we say the term ought not to be implied, the wider formulation of the term, which is the provision of a treatment plant.
So the third reason is?
This is the third reason, please, my Lord, that to invalidate the award, the point must have been specifically raised.
Yeah.
So going back to my erroneous point, Mrs. Jackman-Loomy, the Court of Appeal was wrong, you said, to imply that term.
Yes, please, my Lord. We're saying that it was unnecessary in these circumstances because of Clause 8.1, the combination of Clause 8.1 and the action complained about in these particular.
Yes, I mean, the key point on procedural matters is that this was not the pleaded case that you had to meet and the arbitrators had to consider.
Indeed, please, my Lord.
Yes.
And
forgive me, I don't believe I understand your third proposition at the moment, your third way of putting it. Could you help me?
So, my Lord, just to be clear, so the first one was because of Clause 8.1,
yes.
Yes.
There was no need to imply a term.
Yes.
The second one related to the question, well, assumed that Global would be advancing, that the wider formulation was advanced but not considered. And our response to that was that that error is not patent on the face of the award.
Yes.
The third, which is what we're discussing now, is that to invalidate the award, the point in question, so the point being impugned, must have been specifically raised during the course of the arbitration. And that is where the discussion on Russell and Zumwalt and National Housing Trust had started, because those were used as authorities for the proposition that a decision on a basis not covered by the submissions or evidence in the arbitration proceedings is liable to be set aside as misconduct.
It could be set aside as misconduct even if it hadn't been pleaded.
Well, my lady, if it had been pleaded and the arbitrators failed to consider it, then that could have amounted for misconduct. So quite frankly, after the arbitral hearing, when we received the award, the arbitrators had decided that there was an implied term that the government ought to have provided a treatment facility, not the prepared site, government would have been entitled to apply to have that award set aside for misconduct, quite frankly. Yes. Because it would have been the arbitrators deciding a matter that was never ventilated during the arbitration. Not by the pleadings, not by the evidence, not by the legal submissions. It never arose at all.
I think you would say, to the extent that Mr. Strong says that, in fact, in the arbitral hearing, he raised arguments directed to the wider term, even though not pleaded. He wanted to say that the arbitrators had gone wrong by not dealing with that wider case. The proper way forward was an application under Section 25 to say, well, it was misconduct for them not to have dealt with that wider case.
Please.
And there's never been such a case put forward.
Indeed, please, my lord. And certainly there was a case for misconduct put forward by Global before the commercial court, but again, it was tied up with error of law on the face of the award. That is how they particularized it, because certainly we did ask for further and better particulars of that particular pleading, and what they said is that it's still related to error of law on the face of the award, but they were seeking to have as an alternative the remedy of setting aside instead of remission, which is what the court ultimately ordered. So if I may take you to the reference to arbitration under the MOME, and that is at MS page 489. So you would see the heading, Management, Operation and Maintenance Agreement, Notice pursuant to Clause 14, Dispute Resolution. Paragraph 6, which is on page 490. The prepared site and the other matters required to be provided by the government under Clause 6 of the Design-Build Agreement are necessary for the installation of the water treatment facility and for its subsequent operation. Paragraph 7.
Sorry, just before you get there, were you going to say anything about paragraphs 2 and 3, which were the particular paragraphs that Mr. Strong, I think, focused upon in terms of the jurisdiction of the arbitral tribunal? Because he says the reference in paragraphs 2 and 3 is in very general terms.
Yes, please, my lord, but it will come back to my point that a party is not allowed to plead a case vaguely or widely, because the point of pleadings is to put the other side on notice as to what your case is. So it could not be that you're just pleading that any implied term or unimplied term should be incorporated into the agreement, because the respondent would never know where to start to begin to respond to a case in those terms. And certainly, while 2 and 3 may have been general, by the time we get to paragraph 6 and 7, we now get very specific.
Yes, but I mean, paragraph 4 says the company's case against the government includes but is not limited to the following matters. So insofar as one draws a distinction between jurisdiction on the one hand and pleadings on the other, and I've already said this, I follow your case in relation to pleadings distinctly, but insofar as you're making a case on jurisdiction,
yes, please, my lord.
Isn't it fair for Mr. Strong to say that if you read paragraphs 2, 3 and 4 together, it makes it clear that in jurisdictional terms, a very wide reference has been made to the arbitrators?
Well, my lord, I would say that although paragraph is very wide, it is not an acceptable pleading, not in terms of court proceedings and not in terms of arbitral proceedings either, because you must put the party on the other side on notice as to the parameters of your case.
Yes, well, that's a pleading point. I mean, I suspect we can't take the point much further as to whether it's jurisdiction or pleading, but you clearly have a pleading point, which is that the arbitrators were never asked to make a finding that there was an implied term on the terms that the Court of Appeal found.
Yes, please, my lord. But, my lord, even if this, because the authorities are clear that you have to submit the point that is being impugned under a challenge to an arbitration must have been submitted to the arbitration, must have been exposed to comment, is some of the language the cases have used. Yes. So even if it was not pleaded in this particular manner, the question or the idea that it was submitted to comment, whether by evidence or submission, is one that the court must satisfy itself in relation to. So if Global is saying it's not in the pleadings, but it's how we argue the case otherwise, they would have to demonstrate in relation to the transcripts or otherwise that this wider formulation is how the term will advance. And we would come to demonstrate that that was not the case either, that it was always, everything was always in relation to the narrow formulation of the term, the pleadings, the evidence, the submissions. It was always geared to the provision of a prepared site.
Even if they had presented it more widely, we have your submission that the proper course for them was to rely on
indeed, please, my lord. It would take us right back to that submission. Yes, please, my lord. Yes. So, my lord, I had just pointed out paragraph 6. Paragraph 7, it is an express and or implied term of the management, operation and maintenance agreement that the government should, in accordance with the design build agreement, provide a prepared site for the water treatment facility. And then paragraph 10 and 11, in breach of the MOMA, the government has not performed the government's obligations under the MOMA or one or more of the same. In particular, the government has failed to provide the company with a prepared site suitable for the water treatment facility. So again, as much as there is that general all-encompassing pleading at paragraph 4, we would say it doesn't save Global from the fact that their case is and always was, before the arbitrators, the provision of a prepared site. And similarly, in their points of claim, where they seek to expand on their case, so the points of claim would be the equivalent of a statement of case. And again here, at paragraph 6, they go through the provisions of clause 6.1 of the DBA, so that's on MS page 494. At paragraph 9, in the premises, in order to comply with clause 6.1, it was necessary for the government to provide to the claimant a soils geotechnical report showing that the site was compacted sufficiently. At paragraph 16, it was reasonably foreseeable that if the government did not perform its obligations under clause 6.1 of the DBA, including the items referred to in paragraph 6 and 9 above, the claimant would be unable to install a wastewater treatment facility capable of processing 250,000 gallons, and the 12-year term of the MOMA would not commence. Paragraph 17, it was an implied term of the MOMA that the government would perform its obligations under clause 6.1 of the DBA, including the items referred to in paragraph 6 and 9 above, to enable the claimant to construct and install a wastewater treatment facility capable of processing 250,000 US gallons. Paragraph 31, further or alternatively, the government's failure to perform its obligations under the DBA referred to in paragraph 6 and 9 above as set out above constituted breach of the implied term of the MOMA referred to in paragraph 17 above. So clearly all references to the implied term being a breach of clause 6.1 of the DBA, and in particular the failure to provide a prepared site. Now, just to touch briefly in terms of the submission of this reference to arbitration to the court, Global complains that it was submitted by way of an affidavit that was filed after it had presented its oral submissions. Now, in response to that...
I'm so sorry, can you repeat that for me?
Certainly, please, my lord. So the Global is saying before the High Court, they had presented oral submissions, and after that date, before the government had replied, this affidavit of the 28th of April had been filed, and it's the affidavit of the 28th of April that annexed the reference to arbitration, so that they did not have the ability to treat with it in the first instance in their oral submissions. And our response to that is that if Global's complaint in that respect was legitimate, what they ought to have done is filed an application to strike out the affidavit, or filed an application for leave to respond to the affidavit, and certainly they would have had the ability to respond by way of submissions, because at the stage that the application was, the affidavit was filed, the supplemental affidavit of 28th April, Global submissions in reply had not yet been advanced before the court. Those were advanced on the 15th of May 2015, and those submissions referred to a hearing at which they indicated they had started their oral reply on the 7th of May 2015. So certainly there was an opportunity to respond in terms of legal submissions, and if the complaint was that procedurally the affidavit was improper, there were applications that could have been taken that were simply not. Now, I come, my lords and my lady, to the issue of the transcripts. Now, in terms of whether the transcripts ought to be considered or not, I would say no more than what is in our written case, and I leave it in the hands of the court. But in the event that the court decides to review the transcripts, I would want to point the court to the places in the arbitral proceedings that we say clearly show or further bolster the position that the case before the arbitrators was always the narrow formulation of the term. Now, it's not to say that Global never used the words prevent the commencement date at all, but the way they particularized the breach of that obligation, the alleged breach, was by the government's failure to provide the prepared site. That is the point. So referring to the fact that CL, Sterling and Maitland secured income, all those wonderful authorities that advanced the legal proposition were in fact relied on before the arbitrators. We say it's neither here nor there, because at the end of the day, what Global was in fact doing is saying this is the legal proposition, and the way we are alleging that it was breached in these circumstances is by failing to provide a prepared site, never by failing to provide a treatment plant. That is the issue. So if I may take, my ladies and my lords.
Well, I'm acutely aware that you still have the second ground to argue. I would be content if you just give us the references.
Indeed, please.
And we read them later.
Certainly, please,
in order to give you time to develop your other submission.
Yes, please, my lord.
Would you be content with that?
Yes, certainly, my lord.
Thank you.
So in terms of Global's opening, my learned friend has referred to two passages already, but I would also direct the board to page 315 of the bundle, line 23, to page 316, line 9.
I'm so sorry, I'm not sure I've got the right page numbers. Are you talking about the main bundle?
Yes, please, my lord.
Right, I'm so sorry. Could you just give me those
Certainly.
references?
So page 315, 315.
Yes.
Line 23 to 316, line 9.
Thank you.
Then in Global's closing submissions, page 647, lines 13 to 23. So that is 647, line 13 to 23.
Thank you.
Page 652, line 13 to 653, line 19. And I just wish to state very briefly that Global directed the board to page 653, but it really starts at page 652. That reference I just gave you would put what is said at page 653 into perspective. So just to make that note. Page 658, line 21 to 25. 659, line 15 to 21. 666, line 18 to 667, line 4. And then I just want to make the point that even in the government's closing, the implied term was always framed and phrased as the narrower formulation. And certainly Global would have had a right to reply in the arbitral proceedings, and nowhere in the reply do they say, no, government has misunderstood. Our term is actually the wider term. We actually agitating for the provision of a treatment plant. And the references to the government's closing would be page 743, lines 17 to 25.
Sorry, could you say that again, please?
Sure. 743, lines 17 to 25.
Thank you.
766, lines 20 to 22. 767, line 10 to 13. And 768, lines 20 to 23.
You've still got 40 minutes.
Grateful, please, my lord. So my lord, the fourth point, and I wouldn't need to take the court in because it is in fact in our written case, is that there would have been prejudice occasioned by to the government by the fact that this wider term had not been advanced. And it comes back to everything that I was saying before. We would not have taken instructions on this point. We would not have led pleadings on this point, evidence nor submission. So I need say no more than that. Now, in terms of the narrow formulation of the term, to provide a prepared cite, and luckily much of what I would say here is bound up with our arguments as to why the DBA, the damages for breach of the DBA would be considered too remote as well. But just to make a few points before I launch into that argument, Global has suggested that the arbitrators were wrong because they had held that no term should be implied at all, and that at the very least they should have implied a term that there was an obligation to not prevent the commencement date. And again, it takes us back to the initial references, the initial cases that say that you should read the award in a reasonably commercial way. So the fact that they did not say specifically, well, that is a legal obligation to not prevent the commencement date, but the way it was pleaded in this case, we find against Global, was unnecessary. The fact is that general legal proposition was pleaded in a very particular way, referable to the provision of the prepared cite. The arbitrators made it very clear that term ought not to be applied. It was unnecessary to do so, and they needed to go no further than that. So in terms of the narrower term, the need for the treatment plant, we say that the award ought not to be disturbed because this would be proposing a term that is wider than that which is necessary to make the contract work. And of course, that formula of words I get from several cases, Ali, Marks, and Spencer. I need not take the board to those. So in this case, we are submitting that Global is agitating for a retroactive fusion of the contracts that ought not to be allowed. The DBA and the MOMA were completely separate and distinct contracts in our respectful submission. To put it another way, they were independent and not interdependent. And by that I mean, performance of one was not dependent on whether the second was performed or abandoned. And my lords, I will deal with this under three headings. The first is that there are no express cross-referencing in the contracts. The second is that the court would be unable to imply such a link from the circumstances. So to put it another way, the first argument would be text, the second argument would be context.
You said they're not able to imply.
They would not be able to imply a link or conclude that there was a link. And the third way that I plan to deal with it is to demonstrate that the factors that Global relies on would be irrelevant. The factors that Global relies on to say that the contracts were in fact linked are irrelevant.
When you say no express cross-referencing, what about Clause 9 of the DBA, the reference in the DBA to the management, operation and maintenance phase?
Yes, Mr. To that I say that that clause does not say who was to conduct the management, operation and maintenance of that particular plant. It simply says, and it also does not say that the management, operation, and maintenance was to be conducted in accordance with the MOMA.
But it says the company shall issue a commencement notice.
Yes, please,
No
Madam.
later than 10 days after receipt, indicating the commencement of the phase. You're saying that Global issues a commencement notice. And this contemplates management, operation, and maintenance by a company other than Global.
It certainly leaves it open, please, my lord. And the
That's a very strange commercial arrangement that Company A, who has nothing to do with the management, operation and maintenance, can issue a notice committing another company who may be completely unconnected to take on the responsibilities.
Well, my lord, the importance of the commencement notice under the DBA is simply that it signifies the start of the defects liability period. So that in usual contracts where you would have the plant completed, the plant installed, and then the 1-year defects liability period starts from that date, the obligation on Global to provide a warranty, in other words, for a year.
Where do we see that in the contract? Linking
Clause 12, please, my lord.
12?
MS page 512. There shall be a defects liability period of 1 year after the company issues, I suppose it should be issuing, the commencement notice.
Yes.
So it is our position that it's simply the point at which Global is now responsible for a period of 1 year for any defects, because government, I suppose, for whatever reason, would not have wanted that period to start before the plant was capable of being managed. But again, clause 9 definitely does not state that Global was the one to manage the contract. It could have easily said so. Or that the management, operation, and maintenance ought to have been done in accordance with or pursuant to the MOMA. Again, very simple words to say so.
But if they were wanting simply to bring in the defects liability period, you could have had a full stop in 9, the penultimate line of 9, after taking over certificate. I mean, why refer to this, what on your position would be completely irrelevant phase of the arrangement?
Well, the taking over certificate simply means that the plant and the material is there, it's on site and it's installed. It doesn't mean that the plant is operational, to use those words. And I suppose what government was binding Global to was a commitment that the plant wasn't only physically there, but the plant could be operationalized. And that its responsibility to ensure that there was no defects in the plant would start from the day that they could guarantee in writing that the plant could be operationalized. But it certainly doesn't go any further to say that it had to be operationalized by Global or operationalized pursuant to the MOMA.
I suppose you could say that if for some commercial reason the MOMA had been cancelled by agreement between the parties, the DBA would still apply. It would still be an obligation to design and build the plant. You'd still need a commencement notice. It's just that the commencement would then be into a phase of operation by another.
Indeed, please,
contractor.
my lord. Another contractor, government, but certainly there's nothing on the face of the agreement, objectively speaking, that says that this operation had to be done by Global or the MOMA. And more importantly, my lords and my lady, if I take you through certain provisions of the MOMA, and bearing in mind that contract interpretation is always based on objective criteria at the time of contract, and to use a light-hearted analogy, if the reasonable man had been courting me, and we were discussing these contracts, and I had said that the contracts were inexorably linked, I don't think it is a relationship that would have lasted, because certainly we would not be completing each other's sentences. Because for every clause that I am about to point out to you, where the natural inference would lead to the words the DBA, the MOMA is self-contained. It says in this agreement. It confines itself, its obligations, its liabilities to the MOMA. And again, it would have been the easiest thing in the world to refer to the DBA, to refer to Global under the DBA, but it simply does not. So if I may take my lords and my lady to page 523 of the MOMA. This is the start of the MOMA. And I would start with the recitals. The government, and the second recital, sorry. The government desires the management, operation, and maintenance of a water reclamation treatment plant, more particularly described in Clause 5.2 of this agreement, not the DBA. Then if we turn over to Clause 3.1, this agreement shall be for a period of 12 years effective from the commencement date as defined in this agreement, not the DBA. Clause 4, the definition of treatment plant, and that could be found at MS page 526. It means all mechanical, electrical, and other equipment or installed items located on the site as described in Clause 5.2 of this agreement, not the DBA. Clause 5.1, the company hereby undertakes to manage, operate, and maintain the treatment plant, more particularly described in Clause 5.2 herein, not the DBA. And Clause 5.2, which describes the treatment plant, contains absolutely no reference to the DBA. So this is not even a case, my lords and my lady, where the parties left it open to interpretation, left it open to the reader's imagination. Well, maybe when they say treatment plant in the MOMA, it could be the treatment plant in the DBA. Maybe when they say commencement date in the MOMA, it's the same commencement date in the DBA. The parties were at pains to say that the MOMA was in fact a self-contained contract. So there is absolutely no express term that would justify any linkage, any correlation between the two contracts. That's point number one.
But the design build documents that are referred to in clause 2.
Yes, please, my lord.
They are, we don't obviously have the details, but we do have the annexures of letters involving Pure Stream.
Indeed, please, my lord.
And what are they doing there?
Well, my lord, two responses to that. Number one, I have absolutely no idea. But what I can say is that there's absolutely no reference to them in the operative parts of the MOME. Now, my learned friend made the submission earlier that there's no reference to them in the operative parts of any of the contracts, but that is not in fact the case. Because if we look at clause 12 of the DBA, and this is on page 513, the certificate of discharge, so just bringing it back to Lord Wilson's question, there was a taken over certificate, the commencement notice saying that the plant could now be operationalized, it's now in the management phase, and a year after that, the defects liability period, and once there was the conclusion of the period, the certificate of discharge. And the certificate of discharge would state that the works have been performed and completed in accordance with the design build-up documents and the obligations of this agreement, and in all other matters and respects is accepted by the government. So the design build documents is part of the operative or dispositive provisions of the DBA.
What was the purpose in clause 2 of MOMA in making the design build document, namely Global's proposal, part of MOMA?
Well, my lords, I can't answer that. Safe to say that there's no obligation that flows from it. And certainly it doesn't lead, because it's not even a case where the description or the definition of the treatment plant says that it had to be built by or consist of material from Pure Stream Limited or material provided by or installed by Global. There is absolutely no clause to that effect. So really and truly, it's surplusage that serves absolutely no purpose in the moment, in our respectful view.
Yes, but the performance of the plant in clause 5.1 had to achieve the quality and quantity required by the design build documents.
Yes, please, my lord. But, my lord, again, it wouldn't be those two letters from Pure Stream, because certainly those letters from Pure Stream don't refer to the volume. So, if anything, it would refer to the proposal that is not actually annexed to the...
But it's not correct to say that there are no operative
Indeed,
clauses to which the design build documents are relevant.
Indeed,
Clause 5.1 clearly requires the company to produce, to maintain, rather, the plant operating to achieve standards set out in those documents.
Indeed, please, my lord, I take the point that I would have missed that, but I would say that it doesn't disturb the arguments otherwise. So, my lord, going to the second submission, that a link cannot be implied from the circumstances, we say it is relevant that the contract was concluded on the same day, meaning that the separation of the contracts must have been intentional and not just merely as a result of the course of dealings or the parties at the time not appreciating that there was the DBA that preceded it. It would have been very intentional. It covered essentially the same transaction. It was not a chalk and cheese situation, to put it that way, so that there was every opportunity to conclude either a single composite agreement, maybe Part A dealt with the design build, Part B with the MOME, or even if for whatever other purposes, because my learned friend has indicated there may have been reasons the parties wanted it separated, and that may be so, but then they could have cross-reference each other. In the recital, this follows from the DBA. This governs the management of the treatment plant described in the DBA. Nothing of the sort was done. Yeah. And that point is especially poignant when you consider it's the same parties. So again, every opportunity to either conclude a single composite agreement or have that cross-referencing. And my lords, if we step out of the example, or out of the factual matrix that actually occurred here, and contemplate the situation where, for instance, let's assume the DBA had in fact been brought to fruition, and there was a plant constituted and completed under the DBA. If government had decided, I don't want Global to manage this DBA facility, I'll give it to Giselle Lumi to manage, for ease of reference. There's a facility that was built by John Smith, and it fits the description of the treatment plant, and I will give Global to manage that facility. Based on Global's argument, they would have been able to reject that plant and say no. Although it fits the description, in every aspect, it conforms to 5.2. I am not managing that facility. You have to give me the facility that I built. And certainly we are submitted that cannot be the case. And it just serves to demonstrate the extent to which the contracts were delinked, the anti-incorporation climate in which these contracts were concluded.
I'm sorry, are you saying that MoMA, your obligations under MoMA, could have been discharged by asking Global to manage and operate a different site?
Not a different site, a treatment facility as described and on the location described in the MOME. So once it fulfilled all the criteria of the treatment facility defined in the MOME in terms of location, in terms of description, we would have fulfilled our obligations regardless of performance or abandonment of the DBA. And the ability for us to perform our obligations under the MoMA, despite what occurs with the DBA, whether performance or abandonment, is the very test of divisibility. It is the very reason why we invite the court to conclude that the contracts were delinked, separate, distinct, independent contracts. And my lord, similarly, to use another analogy, And this would take me to the remoteness and Hadley and Baxendale position, because again, the arguments in relation to both would be essentially the same, the delinking of the contracts. Because to be able to establish that you're entitled to damages under Hadley and Baxendale, and just as we're here, I heard my learned friend say that I had submitted that Hadley and Baxendale is no longer proper authority. Just to make it abundantly clear, that was certainly never my position, never my submission. But in the Hadley and Baxendale situation, the innocent party would have to establish that the breach, well, let me say Hadley and Baxendale as applied in Victoria Laundry. The innocent party would have to establish that the breach of contract 1 led to either the breach or impossibility of performance of contract 2. And we're saying that Global would be unable to demonstrate that in these circumstances, again, because the contracts are delinked. And again, it brings me back to Global agitating after having concluded 2 separate delinked independent contracts, agitating for a retroactive fusion. And it's why I started the submission with the fact that it's not the court's aim or objective to try to save the parties from their imprudent contract dealings. That's what was agreed. Or imprudent approach to the arbitral claim, because again, there was never a claim that we ought to have provided a treatment plant. There was never a claim that we were in breach of clause 8.1. So that is what has led ultimately to the failure to recoup damages in this particular matter. And just to touch briefly on it, the idea that government is not prejudiced because there was no plant provided anyway. The question at the end of the day is, was that the matter ventilated before the arbitrators? Because what was ventilated, as I'm at pains to demonstrate, was the provision of a prepared site. That is the narrow question that was submitted for consideration. Nothing further. So, my lords and my lady, I just wanted to use the analogy of if Global had concluded, if government had concluded the DBA with a third party. So, for instance, there's a contract to design and build a treatment plant with Lumi Construction Limited. And then there's MOMA. So that first contract is between Lumi Construction Limited and the government. The second contract is the MOMA with government and Global to manage a treatment facility that bears a similar description. Would it have been necessary to make the contract work to include a term under the MOMA that there be a prepared site for a treatment facility to be built? Obviously not, is our submission.
Did the government argue before the arbitrators that the argument that found favour with the Court of Appeal, which was that someone else could build the plant rather than Global and provide it, therefore there wasn't a link to the MOA? Was that argued?
Certainly not so pointedly, my lord, but
no.
Our argument had always been that the contracts were delinked.
The contract, you said that there were 2 contracts, but you didn't argue, as I understand reading the award, you didn't argue the factual argument which found favour with the Court of Appeal that MOMA could be performed even if the DBA wasn't completed.
Well, my lord, I would respectfully submit that it's not so much a factual matter as it turns on the construction of the contracts. Because although the Court of Appeal went to the heart of the issue, peeled the layers back and went to the heart of the issue, that the fact is somebody else could have built the plant. By us making the very fervent submission that the contracts were delinked, it lends itself to that conclusion as a natural corollary. Because the contracts are linked and therefore the MOMA could be performed sans the DBA and sans Global. And
we know in paragraph 17 of the award there was a finding that performance of the MOMA was manifestly conditional upon the completion of the DBA.
Yes, please, my lord.
Yes.
And my lord, I would respectfully submit that that is the arbitrators finding those facts and not necessarily saying that as a matter of contract, that was the case, because those are two different things. The arbitrators, at the time that they are delivering this award, has had the benefit of the pleadings, the submissions, the evidence. And they can take a step back and say that obviously to the two parties, this A was meant to lead to B. But what we are concerned with when we are construing the contracts is the position at the date of execution, considering the contracts on their face and the facts and circumstances that would be available to read the intended or the reasonable reader of those documents. And we would say when that exercise is engaged, there is no basis for saying that it inevitably followed that if you didn't perform the DBA, you could not perform the MOMA. That is not a conclusion that could be arrived at in terms of the parties' contractual obligations.
But you didn't challenge that sentence in paragraph 17. You didn't say that this was an error of law or this was a factual error or anything like that, did you?
Well, no, my lord, because even if as a matter of fact that was the case, it really wouldn't disturb whether as a matter of contract we were obligated to perform the MOMA by reference to the DBA. And that is really the question that the arbitrators were concerned with, because what they found was that there was this inextricable link between the two contracts. The parties must have known that, and again reiterating, they're able to come to that determination after hearing the evidence, after reading the pleadings, after hearing submissions.
Yes.
But what they found is in the face of that vital interconnection, factually speaking, that what happened, contractually speaking, is that the parties split the obligations.
Indeed so. But you're not disputing that whatever the Court of Appeal may have said, the factual situation presented to the arbitrators was that factually there was a link. And what they have said is, notwithstanding that vital interconnection, they've chosen to have two separate contracts, and those two separate contracts, the existence of those two separate contracts gives rise on the part of the arbitrators to an inference that was deliberately to disconnect.
Yes, please, my lord.
Does it come to this, Mrs. Jackman-Lume? You ask us to dismiss this appeal on the basis that the arbitrator's reasoning was correct about the two independent contracts. You don't ask us to dismiss the appeal on the basis that the Court of Appeal's hypothesis, namely that it would have been in the contemplation of the parties to MOMA that a third party should build the treatment plant. You don't ask us to dismiss on that basis.
Indeed, please, my lord.
Thank you.
Thank you.
Can I ask, insofar as you've been dealing with the remoteness part of the argument,
Yes, please, my lord.
might it not be said against you that the test there does in fact depend upon what in fact the parties contemplated? And I think you, even in the way you've been putting it to us, that the two contracts covered essentially the same transaction. It was obviously the intention of the parties that A was meant to lead to B. Seems to suggest that you accept, in fact, that on the facts, it was in the contemplation of both parties that the DBA was intended to lead to the MOMA.
Well, I'm not sure that I necessarily concede the fact, but what I would say is that even if it could be said that that was the actual situation from a factual perspective, that was in fact the contemplation of the parties, the knowledge and the contemplation of the parties could only be relevant insofar as it then led to the formation of binding contractual obligations. Because actual knowledge is not necessary to found or ground either a breach of contract or compensation in relation to same. Because certainly if your actual knowledge was necessary, the engineers in Victoria Laundry would have said, well, I didn't know. I didn't know that they needed this boiler. That's in fact what they said to launch their profits. But the court found, as a matter of contract, regardless of what you own, as a matter of contract, this was the position. So this is why I'm urging the court to step away from the actual knowledge, or what is perceived to be the actual knowledge of the parties. And in terms of implied terms, and it was the dissenting decision of Lord Kerr in the case of Ali, pardon me, lady?
I'm sorry, I didn't hear the case name.
Oh, the case of Ali?
Oh, yes, of course, Ali.
Yes.
Sorry,
Lord Kerr, it was a dissenting decision, but he just used the phrase inadmissible retrospective dimension, to be aware of that, because it's easy when you sit after the fact and you're able to glean all the facts to be critical and imply terms or find remoteness. But the court must disabuse its mind of the factual matrix and look objectively at the contracts to determine not what the parties knew, didn't know, actually contemplated, but what they agreed to, what they were bound by. Because that's the relevant question at the end of the day.
And just pursuing that into the judgment of Lady Hale and her formulation in the Appellant, you're saying that the government should not be taken to have undertaken legal responsibility for the type of loss that would be incurred if MoMA was not performed.
Indeed, please, my lady. That is exactly what...
Was Lady Hale saying that?
Well,
Mrs. Jackman-Loomy?
Well, my lord...
She is quoting Lord Hoffman and saying she doesn't like it.
Yes, my lord. And my lord, to be fair, and I realize the confusion from the way I put it in my written case, because I was actually trying to capture what Lady Hale was saying about the test propounded by Lord Hoffman. But I do understand that it was a dubitante decision that she gave, that she expressed some doubt in respect of it. But even without, because certainly the arbitrators never relied on transfer. That is me trying to take the award even further, because they referred to Hadley and Baxendale and Victoria Laundry. But the point of it remains that our submission is that based on the way the contracts were structured, government cannot be taken to have accepted the risk, the type of loss that has occurred in this particular matter. That's the bottom line at the end of the day. So, my lords and my lady, if I may just quickly touch on some, just make sure that there's nothing that arose during my learned friend submissions that I didn't cover. Yes, I believe in my submission, I would have essentially dealt with, just one final point that I wish to make, because my learned friend made heavy weather, not so much today, but certainly in the written case, that the arbitrators had held at paragraph 39 of the award that one consequence so that is at page 16, MS 16. It is true, as Global argues, that one consequence of the breach of the DBA was that Global lost the profits it expected from the MOMA. So they make heavy weather of the fact that the arbitrators indicated that it was one consequence, but our contention is that that would take the case absolutely nowhere. In Hadley and Baxendale, the sole consequence of the loss of profits was the failure to deliver the shaft. In Victoria and Laundry, one consequence of not getting the boiler on time was that they lost very lucrative contracts with the Ministry of Supply. In Transfield and the Achilles, one consequence or the sole consequence of not getting the much higher profits was the failure to deliver the boat to the owner so that the follow-on charter could occur.
Yes, you say factual causation has to be qualified by the legal requirement of remoteness.
Indeed, please.
Essentially, that's the point.
Indeed, please, my lord. And paragraph 29, which is on page 12 of the record, the fact that the parties would have been aware of the profits to be made under MOMA, certainly there is no indication that those profits under the MOMA were dependent on performance of the DBA. Unless I could be of further assistance, those are my submissions.
Thank you very much. Mrs. Barry, do you follow?
No, my lords.
Having regard to the time, having regard to time, your learned senior has given you only a minute and a half. Thank you. Mr. Strong.
Can I begin by picking up the points that were made at the end about the claim for breach of the DBA, please? What my learned friend said was that Global has to demonstrate that breach of contract 1 leads inevitably to non-performance of contract 2, that breach of the DBA leads inevitably to non-performance of the MOMA. Now, my lords and my lady, that is simply wrong as a matter of law. It's not a question of, is it inevitable? The question is, was it within the contemplation of the parties that the non-performance of the MOMA was a not unlikely result of breach of the obligation to provide a prepared site? So most of what the learned friend's submissions have been aimed at is the wrong target. The learned friend accepts that paragraph 17 of the award, which says that the MOMA was manifestly conditional upon performance of the DBA, is a finding of fact. If that is a finding of fact, that's the end of the matter. There's no getting around it. The way that the Court of Appeal tried to get around it was by saying, well, it's not really a finding of fact, it's a finding of law, and it's wrong as a matter of law. But if it's a finding of fact, then there was no way of performing the MOMA without the DBA being performed. My learned friend also said that it's not a matter of actual knowledge of the parties. She's right in the sense that if reasonable persons in the position of the parties would have contemplated that a particular loss was not unlikely to result from breach, it doesn't matter if the particular parties didn't actually contemplate that. That part is correct. But if they did actually contemplate it, and the award says they did, then of course it's relevant, actual knowledge is relevant. Of course, if the parties actually realised that non-performance of the DBA would result in loss of profits of the MOMA, then the test of remoteness is satisfied. So, for those short reasons, I submit that I win on the DBA. Now, let me then deal with the points that my learned friend made about whether there's an interconnection between the contracts. And let me be clear. Of course, I accept that they are separate contracts. But it is quite obvious from reading the contracts that there is a very considerable linkage between them. My learned friend repeatedly said, well, the MOMA refers to this agreement. It doesn't refer to the DBA. But when one looks at the clauses she was referring to, the definition of the treatment plant is defined in the MOMA as the treatment plant as described in clause 5.2 of this agreement. Now, the parties knew that clause 5.2 was identical to clause 5.1 of the DBA. It's a nonsense to say that they're not talking about the same thing. As my Lord Hodge pointed out, I was wrong in saying that the design build documents weren't referred to in the operative parts of the agreement, and I'm sorry that I missed that. But the clause that Lord Hodge referred to is very pertinent, that the MOMA, it's 5.1 of the MOMA on page 527. What the global water is undertaking to manage is the treatment plant described in 5.2, i.e. the same as the treatment plant described in the DBA, as specified in volume 1 of the annexed design build documents. So, and they are the ones which are also referred to in the annex to the DBA, and which, as my learned friend pointed out, define what under the DBA has to be built, because if the plant doesn't perform in accordance with those documents, Global has to repair it.
It may be in 5.1 that the reference to the design documents is a reference to the specification of the quality and quantity of water. I think that's how I'd read it, rather than the treatment plant as specified in volume 1 of the design build documents. But the point remains that what was being envisaged was something that had been designed, and we know that Global had designed it to achieve certain standards.
Precisely.
And it is those precise standards that are to be given to Global in the plant to operate.
Yes, my lord. Yeah. And for the purposes of the claim under the DBA, one has to remember that the question is, what would the parties, reasonable persons in the position of the parties, have envisaged as not unlikely to flow from the non-performance by the government of the DBA? Well, given these very close linkages between the contracts, it's plain it's inescapable in my submission that it was not unlikely that the MOMA couldn't be performed, wouldn't be performed, and that Global would lose its profits. In order to make good my claim under the DBA, I don't have to establish that if the government abandoned the DBA and went and got somebody else to build a plant on the site, that wouldn't have satisfied the MOMA. It's just neither here nor there. That's not the relevant question. It might not have satisfied, it might strictly not have satisfied the MOMA, albeit that Global wouldn't have suffered a loss in those circumstances if the right sort of plant had been built. But that's not the question under the DBA. So let me then turn to the alternative claim, if I need to get there. For breach of the implied term of the MOMA. Now, in my submission, one has to be careful in using phrases like narrow term and wide term in understanding exactly what is being referred to, because a lot of my learned friend's submissions were directed to asserting that there was no implied term that the government would deliver the facility to Global, which is what the Court of Appeal held was the implied term. And I made quite clear that I did not say, it's absolutely certain that I did not argue that in front of the arbitrators. It's not what I was asserting today. I said that my primary submission was that the Court of Appeal was wrong about that. So, again, a lot of the submissions were aimed at the wrong target. Learned friend had a number of reasons for saying that there shouldn't be, that my claim fails. Let me put it that way. She had one reason which arose out of clause 8.1, and the rest she described as procedural points. The clause 8.1 of the MOMA, which is on page 531, that point can be disposed of very quickly. My learned friend's proposition is that there can't be an obligation to provide the plant because there can't be an implied obligation to do that because there's an express obligation to do so. As Lord Hodge pointed out, that's not what clause 8.1 says. Clause 8.1 only comes into effect, and can only come into effect, once the plant is in existence. What the clause says is that the government represents that it's the owner of the treatment plant. We know that it wasn't at the date the moment was signed because there wasn't a treatment plant. And then this is really the point that my learned friend moves on to. The government represents that it shall at all times during the term of this agreement grant the company access to an egress from the site. That obligation is only to grant access at all times during the term of this agreement. The term of the agreement is the 12-year term which starts on the commencement date. It can't be this cannot import an obligation to provide the site in the first place, to provide the plant in the first place. So I did not make a mistake in failing to plead a breach of that clause. So then we get to the procedural points that are taken. And the first one was to consider the hypothesis that what learned friend called the wider form of the implied term was advanced in front of the arbitrators but was not considered. Now, can we just begin by looking at part of the award that I haven't taken awards to before, which is the actual award itself rather than the reasons, on page 2. And clause 2. Paragraph 2, as I should say. We find that there was no implied term of the MOMA that the respondent was to deliver a prepared site to the claimant on which to build the facility, and that there was no breach of this agreement. That is the proposition of law which I say is wrong. And that, to answer Lord Sales's question from before the short adjournment, is the error of law on the face of the award. Now,
sorry, just on that, doesn't one naturally read the award in the light of the reasons?
Now, the suggestion is that if Global advanced a particular formulation of the implied term, and that wasn't considered by the arbitrators, that then Global's remedy would be to seek to have the award remitted for misconduct because the arbitrators had failed to consider something. The answer to that is that the breach that Global relied on is the failure to prepare a site. I couldn't have said to the commercial court, the arbitrators failed to consider whether preparing a site was a breach of the MOMA, a breach of an implied term of the MOMA. As my learned friend has pointed out, that was the only, apart from the bits about provision of electricity and that sort of thing, but the key point that Global made in the arbitration was that the failure to prepare the site constituted a breach of the DBA, an express term of the DBA, and a breach of an implied term of the MOMA. Now, that's why there isn't any difference between the articulation of the implied term in terms of failing to, in terms of preventing the occurrence of the commencement date, and an articulation of the implied term in terms of not preparing the site. On the complaint that was being made, it's the same point. The one is wider than the other, but it's the same point.
It is the same point, but when you're contending for an implied term, I think it's pretty well established that you have to put to the court for its consideration precisely what that term is that you're implying.
Well,
and we get back to the point that was made earlier, that you have particularised the Mackay and Dick line of reasoning to a specific formulation which the arbitral tribunal weren't persuaded was the correct implied term.
Well, Lord Sales asked me what exactly was the implied term that I put to the arbitrators orally, and I found it in the transcript. It's at page 653. Line 14, I turn to the issue of the implied term in the MOMA, and I said, we say that it was an implied term, that the government had to do those things that I've just mentioned. That's
sorry, which line?
Sorry, I'm starting at line 14.
Thank you.
I said, or line 15, we say that it was an implied term that the government had to do those things which I've just mentioned, and those are the things that it had to do under the DBA, including preparing a site, or at any rate, that it wouldn't do anything that would prevent the building of the treatment facility. So
just on that, the first formulation married up with your pleaded case, but the extension didn't.
Because it wasn't anything different. I wasn't saying that there was any way in which the government had prevented the building of the treatment facility other than by the things that than by failing to prepare the site and failing to provide electricity or whatever it was. The fact that those things were obligations under the DBA is neither here nor there. You know, that was incidental. The point was that that's what they hadn't done. So I couldn't have said the arbitrators didn't consider whether failure to prepare the site was a breach of the agreement. They had considered that, and they found that it wasn't a breach. The next point that...
Surely on that, since the arbitrators were so clear as to what they understood the argument to be, namely, looking at page 653, the narrow formulation in the first bit that you cited to us, not the wider formulation, why, if you wanted to say, well, they should have considered the wider formulation as well, would it not have been open to you to try to bring a claim based on misconduct under Section 25?
Forgive me for saying that this is slightly dancing on the head of a pin. It was always the same lack of preparation of the site that Global was relying on.
Yes, thank you.
It wasn't saying there was some other way in which there had been the government had prevented the building of the facility. So it wasn't seen as something radically different.
So what's motivated you to agitate, as Mrs. Jackman Louis says, for a different formulation, which has caused all this trouble?
I think my Lord is actually asking me to cast my mind back to why I pleaded it in the way I did, and I can't remember. But I am where I am.
Yes, indeed. Okay.
Now, the next point that, and I don't feel particularly agitated.
I think agitate was being used transitively. You're meant to be agitating us.
Well, I hope I haven't. I hope I haven't. At least not in a bad way. The next point was on the hypothesis that the alleged that the term was not advanced in front of the arbitrators, and it said to invalidate the award, the point must have been raised. Now, I'm not seeking to invalidate the award on the basis that there was some point that I raised that's not the basis of my sorry, let me put this slightly differently. I'm not seeking to say they've decided a point which wasn't there. So it's not saying that as happened in National Housing Trust case, I'm not saying that the case has been decided on a basis that wasn't covered by submissions or the evidence. Now, we then got into the debate about jurisdiction and pleading, and I'm not going to embark on jurisdiction because the board has my points on that, and my submission they weren't answered. But on the pleading point, my learned friend said, well, she's suffered some prejudice because of the way in which she would suffer prejudice if I was allowed to put the implied term by reference to by reference to preventing the occurrence of the commencement date rather than by reference to preparing a site. But what that prejudice is hard to discern. Mrs. Jackman-Loomy says, well, I'd have taken different instructions and I'd have wanted different evidence and I'd have made different submissions, but what would these have been? The only point that that Global has ever made was that the failure to prepare the site prevented the occurrence of the commencement date. That was squarely before the arbitrators on the pleadings. If Mrs. Jackman-Loomy or her leader at the time, the Attorney General, had wanted to say, but it didn't. The plant could have been built anyway, even though you hadn't, even though the site hadn't been prepared, or as the Court of Appeal hypothesised, somebody else could have built it somehow. That's something that could have been advanced before the arbitrators on the pleadings as they are, and it wasn't. So in my submission, there's no basis for saying that there would be a problem about amending the pleading if I needed to. Just finally, it's final. Finally, I should just make this point about the implied term and what the Court of Appeal said. Now, I've made the point that the implied term can't be to deliver a plant, because that's an express term of the DBA. The reason why the Court of Appeal got there, the reason why the Court of Appeal said that that was the content of the term not to prevent the occurrence of the commencement date, was that the Court of Appeal disagreed with the arbitrators, and the Court of Appeal thought that it would have been possible, as a matter of fact or law, for a plant to be constructed other than under the DBA, other than by the government preparing the site. And the Court of Appeal said, well, maybe the government would have gone and got somebody else to prepare the site and got another contractor to build a plant, and that would have satisfied the commencement date. And so the reason the Court of Appeal got to its conclusion is undermined by precisely the same point, which undermines its conclusion on the DBA. And if one strips out that misconception, what you get from the Court of Appeal's judgment is that there was an implied term that the government wouldn't prevent the commencement of the... and that means preparing a site. So it actually, the pieces all marry up. And the Court of Appeal's reason for saying that the arbitrators didn't consider the term which it found is equally undermined by the very same point. Once one understands that the correct way of putting the point about not preventing performance of the commencement date is that means that the government has to prepare the site. Once one understands that, then that is the point that was put to the arbitrators, and the Court of Appeal's reason for upholding the appeal falls away. The very last point, and it's probably a small point. My learned friend began by suggesting that the question here is whether reasonable arbitrators might have come to the view they did. That's not the test. The question is there an error of law on the face of the award? That's not a matter of discretion. The law is what my lords and my lady will find it to be. The arbitrators will either have got it right or they've got it wrong. Saying that different lawyers might come to different views is not a relevant exercise here. The cases that a learned friend refers to are cases where are not pure points of law. As my Lord Jones pointed out, the NEMA is a case about frustration. It's about whether these facts are enough to make the contract radically different from what it was said to be. Edwards, which my learned friend didn't take you to but referred to, is an appeal against the assessment of the General Commissioners of Tax about whether a particular activity was an adventure in the nature of a trade.
Exactly.
That is plainly something that entirely depends on the facts.
It's an evaluative exercise.
Precisely, my Lord. And that's not the exercise that we're embarked on here. So unless there's anything else I can assist the board with, those are my submissions.
Thank you very much, Mr. Strong.
Thank you.
Well, it only falls to me to thank Council for their helpful submissions, and also thank those behind them who have contributed to the preparation of this appeal in having the documents in a very manageable and understandable form. The board will take time to consider what advice they will humbly tender to Her Majesty.